Here's the third way to get around the no third-party standing rule. Organizations can sue on behalf of their members, but like everything in the standing doctrine, it comes with traps. Hunt v. Washington Apple in 1977. The Supreme Court created a three-part test. Organizations can sue for members if 1. The members themselves would have standing, 2. The lawsuit relates to the organization's purpose, and 3. Neither the claim nor the relief requires individual members to participate. Sounds reasonable. Environmental groups can sue about environmental harm to their members. Civil rights organizations can challenge discrimination affecting their members. Nobody has to round up individual plaintiffs. But watch how this plays out. Part 1. Members would have standing. You'd think, we're an environmental group with thousands of members who use public lands. That should be enough. Wrong. Courts demand you identify specific members who will specifically visit the specific area affected. In Summers v. Earth Island Institute, the court said naming one member isn't enough if that member hasn't shown concrete plans to visit that exact forest tract. You need affidavits. You need proof. Part 2. Germane to the organization's purpose. This lets courts second guess what organizations are really about. A group focused on racial justice sues about environmental racism. Germane? Maybe, maybe not. Courts decide if your issue really fits your mission. Part 3 is the killer. Neither the claim nor the relief requires individual participation. This sounds helpful. You don't need individual members in court, but here's the trick. If you're seeking money damages for harm already suffered, courts say that requires individual participation because you'd need to prove each member's damages. So, organizations can only sue for declaratory judgments or injunctions. Forward-looking relief. You can challenge a law before it's enforced, but you can't compensate members for a harm that was already done. The test creates absurd results. Organizations end up recruiting testers, people who deliberately expose themselves to challenged practices just to create standing. A fair housing group sends testers to experience discrimination so then the organization can sue. Courts accept this fiction because without it, standing doctrine would prevent legitimate civil rights enforcement, and it's selective. Conservative groups, especially states' attorneys general associations, sail through all three prongs. Progressive civil rights organizations face intense scrutiny. Are your members really injured? Is this really germane? Don't you really need an individual participation? Organizational standing was supposed to make constitutional litigation more practical. Instead, it's another gatekeeping mechanism.